So just to recap from part 3 of this series, I concluded with this argument. 1. The Delphic imperative, know thyself, is a divine command. 2. Divine commands must be obeyed. 3. Obedience to divine commands is pleasing to God. 4. Philosophy aims at self-knowledge, therefore the practice of philosophy, insofar as it is obedient to the divine command to self-knowledge, is pleasing to God. 5. Divine law takes precedence over human law. 6. No human institution can prohibit the carrying out of divine commands. Therefore, 7. Insofar as philosophy is motivated by obedience to divine command, philosophy lies outside the jurisdiction of human ordinances. So just a further comment on this argument, number 5 states that divine law takes precedence over human law. So an objection might be raised from the position of atheism. But as a matter of fact, atheists have no problem with this. They simply turn it into a conditional proposition as follows. If God exists, and if God lays down a law we must follow, then divine law must take precedence over human law. The atheist disputes the existence of God, but does not necessarily dispute what would follow if God existed. Out of this, a question emerges. What is the deeper meaning of the claim by Socrates that the practice of philosophy is somehow divinely ordained and outside of state jurisdiction? What does this mean, reframed in purely philosophical terms? Well, in broad terms, philosophy involves the use of reason to attain knowledge of fundamental things. Reason itself follows its own path, as the saying has it. We go where the argument takes us. Reason is its own arbiter and judge, and therefore cannot be subordinated to something other than itself, for instance, emotions, passions, desires, and like. Secondly, the possession of reason is a defining characteristic of the human being. Aristotle calls the human the zoon logon echon, or the animal having logos, or reason, if you like. This is defining because it is a unique feature not possessed by any other animal. He also calls man the zoon politikon, the political animal. While many animals are social, for instance lions, bees, or wildebeest, they are not political. This characteristic is unique to man. The possession of reason and being political by nature are deeply connected. The difference between being social and being political is that with the latter there is rational organization involving deliberation, continuous self-conscious acts of organization, decision-making and rule-making. All these acts involve interaction with other reason-possessing beings, and these interactions take place through language. These traits are direct expressions of logos and are only possible on the basis of the possession of logos. Philosophy is the means by which we arrive at truths knowable through the natural faculties. This means that philosophy is a direct expression of human nature, so any attempt to repress philosophy is a repression of human nature. Just to be clear, by philosophy I do not restrict this to the activities of trained academic philosophers, but to that of any human being who raises and pursues the kinds of questions that usually fall within the ambit of philosophy, or what we call philosophical questions. Everyone at some time wonders about such things. What makes my life worth living? Am I truly free in my choices and decisions? Is death the absolute end, or is there something else? What is the best way to organize human society? Just about anyone with a pulse will ask these kinds of questions at some time in their lives. In other words, philosophy is an expression of our nature, and everyone engages in it to a greater or lesser degree and with greater or lesser competence. Now, on the basis of these considerations, we can conclude that the freedom to philosophize involves more than just the principle of academic freedom, but also touches on the principle of free speech itself. Now, let's take the example of a simple proposition, just to flesh out this notion of reason's autonomy. Let's call it P1. The whole is prior to its parts. We should understand priority here non-temporally, that is to say, not prior in time, but logically prior. Once we understand the concept of whole and the concept of part, we will also grasp the truth of the proposition P1. Part logically entails a whole, and semantically, the meaning of part is determined by the meaning of the concept of whole. For example, we might talk about sitting in this part of the room, but the very possibility of referring to a part of a room presupposes the existence of the whole room as such, the room here being the whole. The part of the room does not exist prior to the whole, logically, but also physically and temporally. By indicating a part of a room, we begin from the existence of the whole. By the way, these considerations belong to that branch of metaphysics known as mereology, named from the Greek word meros, which means part. So these considerations are entirely determined from out of the matter itself. The relations are of a logical and self-evident nature. The principle, the whole is prior to its parts, is grasped as true simply by understanding the terms involved, itself an operation of human reason. The foregoing is entirely determined by reason and the reasoning process and the operations of our other faculties, chiefly sense perception. So let's call these our natural faculties. We can identify now at least one reason why philosophical activity cannot be constrained by executive commands and institutions, why human statute or command does not have jurisdiction over philosophy. There is another, and this relates to the nature of lawmaking itself. Lawmaking is itself an operation of our faculties. Lawmaking is an activity that presupposes the use of reason. More than that, it is a very particular form of the expression of reason. Let's take the Road Traffic Act as an example. The aim of this body of legislation is to avoid injury and death, and to facilitate the smooth passage of road traffic in an ordered and predictable way. This greatly contributes to both safety and efficiency of flow. Just imagine road use without any rules. Each and every item covered in this legislation relates to the general aims, safety and efficiency. There's nothing in it that involves arbitrary rules, like just rules for the sake of making rules. There's nothing in it that cannot be explained by reference to its twin aims. It is therefore rational in whole and in part. Ideally, all law is, or ought to be, of this character. The making of law presupposes rational faculties, but also rational aims. By this I mean that any law ought to be intelligible and explicable in terms of aims that tend towards realizing or maintaining the common good. As lawmaking is itself a product of reason, reason applied to practical situations, it would be absolutely absurd to claim that this activity can place restraints on the use of reason, but, moreover, the public use of reason. This would be analogous to something like the child having authority over the parent, or the effect having priority over the cause. It would involve an inversion of the logical order of things. All this may seem kind of obvious to us now, but Socrates lived at a time when these issues were only starting to make their way into general consciousness. Socrates lived at a time when what we should call mythical meta-narratives, that is, big stories about why things are the way they are, were giving way to a new kind of sense-making, one that involved the use of observations, concepts, logical relations, and the like. Throughout Plato's work, he frequently reverts to exploring this tension between what he calls mythos and logos. We get the modern word myth from mythos and logic from logos, but also all the ology-ending words. The poet represents mythos, with Homer having premier authority, but the newly emerging group called philosophers operated in the medium of logos. Many found the latter disturbing because new and unfamiliar, so philosophy appeared to be undermining traditional beliefs and moral maxims, and so by extension, the status quo of the ancient Greek polis. Some scholars have described this as a kind of conservative reaction, and name Aristophanes as a leading representative of this tendency, the author of The Clouds, the notorious lampoon of Socrates, which the latter mentions in his trial speech and which was performed around 30 years previously. Socrates in fact claims that this play has done more to prejudice the jury against him — most jurors would have been old enough to recall the play — than the efforts of these present non-entities who were bringing the prosecution against him. Socrates was not alone in discovering the possibility of a conflict between human and divine law. This was already the theme of one of Sophocles' great tragic dramas, the Antigone, which was performed a full 40 years before the trial of Socrates. I will discuss the Antigone in a later presentation. So first Sophocles and then later Socrates raise an issue that will become foundational to something called the natural law tradition. This will be the subject of a future series, but for now I will briefly indicate what we mean by natural law and the natural law tradition. Largely under the impetus of Plato, Aristotle, and the Stoic school of philosophy, natural law reaches a high level of development under the Romans, to the extent that it is incorporated into Roman juridical thinking. So I'm going to end this series with an important passage from the great Roman jurist Cicero, writing nearly 350 years after the death of Socrates. Some terminological clarification. Cicero was very well educated in philosophy and owed his own influences to Platonism and Stoicism chiefly. The term nature here means something like the real being of a thing, hence the nature of mathematics, human nature, cat nature, the nature of God even. Plato often used the term nature as synonymous with talking about the essence of a thing, what it is for something to be what it is. And so here's the quote from Cicero. It comes from his Republic, Book 3, Chapter 22. He says, "True law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. It summons to duty by its commands, and averts from wrongdoing by its prohibitions. And it does not lay its commands or prohibitions upon good men in vain, though neither have any effect on the wicked. It is a sin to try to alter this law, nor is it allowable to attempt to repeal any part of it, and it is impossible to abolish it entirely. We cannot be freed from its obligations by Senate or people, and we need not look outside ourselves for an expander or interpreter of it. And there will not be different laws at Rome and at Athens, or different laws now and in the future, but one eternal and unchangeable law will be valid for all nations and all times, and there will be one master and ruler, that is, God, over us all, for he is the author of this law, its promulgator, and its enforcing judge. Whoever is disobedient is fleeing from himself and denying his human nature, and by reason of this very fact, he will suffer the worst penalties, even if he escapes what is commonly considered punishment." So I think this passage illustrates quite perfectly what Socrates really means when he says that God has commanded him to philosophize, and when he tells the court that even if they were to order him to cease philosophizing, he would refuse. End quote. So if true law is right reason in agreement with nature, as Cicero says here, then we can now understand more clearly Socrates' refusal to obey any order coming from the polis to desist in philosophizing. This would not be a true law, because it goes contrary to nature, and is also in defiance of divine command. This concludes the series, Socrates and the Laws. The picture I have been using as the series thumbnail, and which features in this presentation in full colour, is entitled Cicero Denouncing Catilina by Cesare Maccari, 1840 to 1919, and it's a fresco in the Palazzo Madama in Rome. As usual, please like and subscribe, but for now, thank you for your attention.